My name is Gary DeSerio, and I will be your instructor for civil procedure. I am a licensed practicing attorney here in Houston. I've practiced law for about 35 years, all in the area of civil practice, both plaintiffs and defense work. And I have a little bit of expertise in this area. So a couple of things that I want to kind of lay down as ground rules before we begin. First of all, there is an instruction sheet that I have posted to this class, and I would advise all of you to read over at least one time the instruction sheet. And the reason is because there's a couple of things that I really like for you all to do, and there's some things that I don't like for you to do, for which you would be counted off, you know, in the grading process. A couple of those things. First of all, it has to do with submissions. You guys will be submitting things such as discussion questions and various assignments, and I think it's beginning in week number 3 that you're going to start doing submitting like pleadings, motions, discovery, those kinds of things. So this is going to require you to use a form file. Now, I post a lot of forms in class. If you see me post a form in class, then what I suggest you do, unless you want to go back and watch this video again to see what I posted, take a screenshot of whatever it is that I post when I post a form. You can save that screenshot, and you can use that when I ask you to prepare, let's say, a plaintiff's original petition. I'm going to post a plaintiff's original petition, and if you screenshot it, you can print it, and you can use that as your form. However, you don't have to use my forms. These are just forms that I've used over the course of my years of practicing law, and they're good forms. However, you can go to ProDoc. Each of you, as a participant in this paralegal school, you have a subscription to ProDoc, and all you need to do is access it. And in this case, the plaintiff's original petition would be, say, like a automobile accident. You look up under plaintiff's original petition, automobile accident, and it will give you a form. But remember, when you download forms, they have lots of blanks and asterisks and spaces and areas that are not filled in. It's your job to fill that information in. So it sounds like it should be self-explanatory. When you get a form, you know you got to fill it in to make it work. But at the same time, I get so many of these submissions. I've been doing this now for the last several years, so I've had hundreds of these submissions to look at, and there's always a large group of people who submit those to me with blanks and asterisks and parentheses and brackets. I don't want to see any of those things. If I see those, then you get counted points off. So when you do your submission, make sure that you fill them out. Okay. So beginning in the 3rd week also, I will have extra credit assignments. And the extra credit assignment is no more work than what you're having to do normally with class. The only difference is that it's something that we will do during class. And the extra credit assignment is you're going to read the case that's in the chapter that we're talking about. And there are 5 or 6 case questions at the end of that case. And if you would, be prepared to answer those questions in class. I write down the names of the individuals who participate and answer those questions. And at the end of the class, you get extra credit. And I submit that to the front office, and that just gets added to your grade. Maybe it moves you up by a couple of points. But I think it's worth it because you're not doing anything more than is going to be required anyway as part of this class. In other words, you may have a discussion question that comes directly from that case, so you've got to read that case anyway. So we have some extra credit assignments, and I like for you guys to participate. I like for you to ask questions. I like for you to, if you have comments with regards to something or something just doesn't make sense, then you need to tell me what it is, or you need to ask your question. I also have a tendency to maybe speak a little quickly because I know this material very well, and to me it's second nature, and I understand to you this is all new material. So what I don't want to do is I don't want to go so quickly during the course of my lecture that I lose some of you. So if during the course of class, as I'm speaking and I'm lecturing about various things, If you think I'm moving too quickly, you can either send me a chat or you can raise your hand and you can ask me if I wouldn't mind slowing down just a little bit, and I'll be happy to do it. But I don't know that I'm going too fast unless you tell me that I'm moving through the material too quickly. So, okay. Other than that, I mean, civil procedure really is the lifeblood of any course. If you're going to practice civil law, you need to understand civil procedure. You need to understand it on the federal side if you practice federal law, or on the Texas side if you're going to practice Texas law, depending on what it is that you're going to do. Some of you may not be from this Texas jurisdiction, and therefore the rules of procedure that I talk about, or the forms that we use, are for Texas courts, Texas district courts, and you may not have district courts, and obviously if you're not in Texas, you're going to have rules of procedure that are going to be different than Texas. Now, for purposes of this class, you need to know what we're doing here in Texas, but obviously for purposes of wherever you're located, if you're in Colorado, then you're going to use the Colorado rules of civil procedure, which I believe mirror the federal rules of civil procedure. Now, during the course of class, some things we're going to talk about are going to be in the federal arena, and some things we're going to talk about are going to be in the state court. I will always identify to you that this is federal court. I mean, if we're talking about Federal Rules 13 or Rule 12B motion, I'm going to be telling you this is federal court only. But for purposes of the forms that you're going to do, you will not do any federal forms. So even though we may see things, and you may read about things in your book that are regarding federal procedure, we won't prepare federal forms in this particular class. So I just want to make sure that everybody's clear on that. And so, so once okay, so I'm trying to think if there's anything else. Discussion questions. This is what I'm looking for when you guys do discussion questions and you answer it. I mean, the question may be something simple like, you know, do you think that the hearsay exceptions have gone too far and basically have swallowed up the rule itself? Or they're going to ask you about the best evidence rule, and what do you think? And if you say, yeah, I think it's okay, you know, you're going to get a response numerically from me in accordance with what you give me. So if you give me a 5-word response, you can imagine that if out of 50, you're not going to get 50, and you'll be lucky if you got 40 out of that, even though you may have answered the question. When you do a discussion question, I'm looking for you to be able to show me the reasoning, show me that you understand the nature of the question that's being asked. For instance, let's just go back to the example about the best evidence rule, and do you think that it's still applicable? Well, the best evidence rule has to do with the idea that the original of a document is always the best evidence of that document. Given the fact that we have all these different formats that you can duplicate documents with scanning and things that you can save, and the word processing that we have available with our computers, that you can make identical copies of something and not be able to distinguish it from an original other than the original ink. And even then, the scanning process brings that ink right out off of the page to the point where it looks like an original signature. But if you were to answer that question and you said, yeah, I think the best evidence rule still is applicable, and said nothing more, you're not telling me that you even understand what the best evidence rule is. So for a question like that, I would expect you to do something like this. I'd say, yes, I think the best evidence rule is still applicable. Even though we have, you know, formats that allow us to duplicate documents, and even though it's an antiquated rule, I think that, in my opinion, that the original of the document is still the best evidence of that document, and therefore I think that the best evidence rule still has applicability. So that might be an answer. That shows me that you understand the best evidence rule and that you understand what you're talking about, and you're giving me your opinion regarding that. So that's what I would expect in discussion questions. Reasons, logic, some kind of explanation that shows that you understand what that discussion question is about. And the more reason and the more logic and the more of an explanation you give me, the more you show me that you understand the question, the higher you're going to get towards getting 50 out of 50 for that discussion question. Okay. So what we're going to do tonight is we're going to go through two chapters, Chapter 1 and Chapter 2. These are not the most interesting of the courses that you're going to have for this semester. And one of the things with regards to civil procedure is that there are some basics, some things that you really need to know before we go forward. And so that's what we're going to be talking about tonight. Unfortunately, I am not in the country at this moment while you're watching this, so I will be back for next Monday night's class, and this will be the only class that will be pre-recorded. So my apologies in advance, the fact that we're having this class and we're not in a situation where I'm live to be able to answer your questions. But I'm going to try to go through and I'm going to try to answer questions that I think you might be coming up with, but I'm not going to burden you with a lot more material than other than what this class is about. Okay. So with that said, let's go to Chapter 1, which is our introduction to the court system. Okay? Good. All right, so we're going to talk about different types of law, what constitutes civil law. We're going to talk about what is the burden of proof, because burden of proof is different in criminal cases than it is in civil cases, and we're going to talk about some of those differences. We're going to talk about how pleadings come into a case. We're going to be talking about, like, there's a finding of guilt in criminal, but there's a finding of liability in civil. So we're going to talk a little bit about those differences. A little bit of constitutional stuff. I don't dwell on the constitutional issues because as a paralegal, my job is to try to instruct you and to inform you and to try to make you the best paralegal that you can be. But truly my goal is to put you in a position where the lawyer cannot do without you, that you have the knowledge and the skills and the ability that the lawyer looks at and says, I can't live without this person, I need to have them in my office. That's what my job is. And so that's what I'm going to attempt to do during the course of this class, is to give you that kind of information, a little bit of hands-on expertise, a little bit of anecdotal comments where applicable about cases that I've dealt with that might be involved with the same types of things that we're talking about. So that's what we're going to do. Indispensability, that is what it is that I'm looking to do. I'm trying to make you indispensable to that lawyer so that you will be a part of that law firm for a very, very long time. So anyway, so what's civil law? Civil law is a particular area, a category that is not criminal, and basically everything that's not criminal in essence is civil. However, civil is broken down into some subsections. For instance, bankruptcy is not really considered as civil law because bankruptcy is an area of law in and of itself. Tax law is not considered civil, but it is an area of law in and of itself. But pretty much everything else, lawsuits, the people involved in automobile accidents, people suing people for breach of contract or breach of a promissory note, people suing each other for defamation or slander or any of those kinds of things, those are all civil matters, and they all fall into this under the rules of civil procedure. What we talk about when we're talking about civil law is that there's a number of things that differentiate civil law from other areas of law. For instance, you have parties in a civil procedure, and it's going to be the plaintiff versus the defendant. Think about in a criminal case, that's going to be something different because in Texas, it's going to say state of Texas versus, and then it's going to have the name of the defendant, the individual, the person that they say committed some kind of criminal conduct will be the defendant in a criminal case here in the state of Texas. If it's in federal court, it'll say United States government versus, and it'll have the name of the criminal defendant. But the plaintiff is the person in a civil action that brings the lawsuit. They say that somebody did something that caused them to suffer damages, and as a result, they're suing the defendant, the party they say that caused the damages. The style or caption is what we talk about is the heading of the lawsuit. Every pleading that gets filed in civil, the Texas civil courts, we're not talking about federal court, we're talking about Texas civil courts, because the style, the format that's used in federal court is different than what we use in state court. But for purposes of our pleadings, we're going to have the cause number for state court is going to be at the very, very top of the page in the center. And that will generally be 2016 dash, and then there's usually a 5-digit number. 2016 identifies it that it's a case from this year or that was filed this year, and then the 5-digit number will be what order did it end up? Is this case number, 52, 63, 5? So whatever that number is going to be, that's going to be the cause number. To the left, you're going to have the plaintiffs always first, and then you're going to have versus the defendant, which comes second. That's on the left side of the page. On the right side of the page is going to be the court designation. That's going to be something like, in the District Court of Harris County, Texas, 80th Judicial District. 3 lines. First line, in the District Court of, second line, Harris County, Texas, third line, 80th Judicial District. That tells us that this is a lawsuit that's in District Court, that it's in Harris County District Court, and that the court that this case fell into, because they go by a rotating method, kind of like Powerball, where you never know which court it's going to end up in until the court is designated, and randomly you're given, in this case, let's say it's the 80th Judicial District Court. Below that is going to be the caption, which is going to be the name of the instrument that's being filed. So in capital letters, you would have plaintiff's original petition, and then you would prepare the petition and all the instruments and everything that goes along with it, and we'll go over that as well. Okay, this is what we just talked about as far as plaintiff versus defendant. That's a civil case. Government or state of Texas versus defendant, that's a criminal case. And in re, such and such is the way it's done in bankruptcy court, so it's different. The complaint or the petition. In federal court, it's called a complaint. In state court, we call it a petition. But either way, it's the same exact instrument. The plaintiff's original petition is the same thing as the plaintiff's original complaint. And then the answer, a lot of times in federal court, they call it a response. In state district court, we call it an answer. So you'd have defendant's original answer in the state court. And the answer is just what it sounds like. The plaintiff files a lawsuit, and the defendant must answer that lawsuit, or else a default judgment can be taken against that defendant. The default judgment means that you didn't answer the lawsuit. And if you don't answer the lawsuit, a judgment against you will be rendered, and then they can go collect that judgment against you. That's why it's very important that you meet the deadlines. Once you've been served, you have 20 days in federal court to answer the lawsuit. In state court, just as we're talking about here in Texas, you have 20 days plus the first Monday thereafter. So if somebody was served on the 1st of the month, then you would count 20 days from that date, and then the answer is going to be due 20 days later. In Texas court, if you were sued on the 1st of the month, and then let's say the 20th day fell on a Saturday, then, or even on a Friday, or even on a Thursday, you're going to go to the next Monday, and that's going to be your answer date. So that's the only difference. You remember the 20 days. It's only different because Texas gives you the first Monday following the expiration of 20 days, whereas federal district court says 20 days. Now, obviously, in federal district court, if it fell on a Saturday or a Sunday, the courts are not open, or on a legal holiday, it's going to be due the next business day. So that's the only difference. So each court, whether you're in federal court or state court, you have what's called federal rules of civil procedure, and in Texas, we have our Texas rules of civil procedure. And that governs everything that happens in a civil case. That governs how the petition's got to be prepared, how it's going to be served, how the guy who gets served, which is the defendant, has to answer that lawsuit, the defenses that you can set forth. It talks about how you conduct discovery, which is how you find out about the other side's case. All of these things are set forth in the Texas Rules of Civil Procedure. So everything that you need to know about a civil case is set forth in the Texas Rules of Civil Procedure. Burden of proof. So in Texas court and in federal court, on the civil side, when we're talking about burden of proof civilly, we're talking about a preponderance of the credible evidence. That means that it's more likely than not that it's true, and therefore that's the standard that we use. That's not a real difficult standard, more likely than not, but when you compare it to, let's say, beyond a reasonable doubt, which is the standard we use in criminal cases, the reason why that's such a more stringent, a stricter standard is because somebody's life or liberty is at stake in a criminal case, whereas in a civil case, the most that's going to be at stake is probably going to be money. Somebody's trying to get a judgment for money. So as a result of that, it's a less strict standard. So that's really all you need to know about burden of proof. Know what the burden of proof is civilly, beyond by a preponderance of the credible evidence, and know that it is a lesser standard than what we use in criminal court. So the outcome of a case. So when a lawsuit is filed civilly, plaintiff sues defendant, case goes, you do your discovery, depositions are taken, case goes to trial, the jury gets the case, and they render something. They don't decide if you're guilty or not guilty, and I always get people that are answering things about lawsuit on the civil side, and they always try to use the terms guilt or innocence. Guilt or innocence has nothing to do with civil law, has everything to do with criminal law. So just remember that in civil law there is no guilt, there is no innocence. You are either liable or you're not liable. That's it. So liability is the question in civil law. That's what we're looking to do, to establish liable. Is somebody liable for damages that were proximately caused by somebody's actions? Example, automobile accident. Some guy runs a red light while you're entering the intersection, plows into your car. What's going to happen is if a settlement is not reached, then you're going to sue that person, and their insurance company is going to answer the lawsuit for them, and you're going to be asking, once you go to trial, for damages. You're going to say, number one, that they're liable because they were negligent in running a stoplight and injuring you, and that liability is the proximate cause of damages that you sustain. For instance, maybe medical bills, maybe you missed work, maybe you had to go get therapy or rehabilitation, maybe you had to go to the emergency room. All of those are damages that flow from that kind of a situation. And damages are nothing more than monetary payments, money that's going to be paid by the defendant to the plaintiff if a jury so decides. But you've got to convince the jury that this other side was at fault in order to get money awarded to you. So what do we have? On the criminal side, we have guilt or innocence. On the civil side, we have liability, and then if the liability is found, we have damages. So I hope I'm not moving too quickly, but I've got two sections that I need to get through, and I want to get through both of these. And what I'm going to do is when we get to the end of Chapter 1, we're going to take a few-minute break, and then I'll come back, and then we'll do Chapter 2, so you guys can take a break at the same time. You don't have to, well, I guess it won't really matter because you can stop this at any time you want while you're watching it and take a break because it's all recorded. So, like I said earlier, I don't really get into the constitutional issues regarding civil procedure and how that sets out things other than the basics. These are things that you would have learned in your civics class, you know, when you were in junior high school or high school or even college. And you understand that there are different branches of government. You have the judicial branch, which is headed up by the United States Supreme Court, and you have the executive branch, which is the president, and then you have the legislative branch, which is the houses of Congress, with the House of Representatives and the U.S. Senate. And things can be done federally, and things can be done on a state level. From the state level, talking about just what we said, you have the same Senate and same House, but it's a state Senate and a state House, and then instead of the U.S. Supreme Court, we have the state Supreme Court. Statutes. Statutes was what I call the black letter law. This is what's found. It's what's called codification. They took things that happened over and over and over again, and they ended up making a statute that said that this is the law, and it's either been done on a federal level or on a state level, but either way, it's the law that we must abide by. If we don't, then we're going to be sued, or criminally, you're going to be arrested if you violate the criminal statutes, or on the civil side, there are statutes that govern us, and we must conform to those statutes. There are also administrative agencies that give out administrative orders, administrative rules, and administrative regulations. A good example of an administrative regulation would be something like the Environmental Protection Agency. That is an administrative agency, and they give out certain rules and regulations. And if you violate those regulations, like you're a company and you're producing waste, and it violates the Clean Air Act, then that's a violation of that, and you're going to be sued under that statute, and you may end up having to pay monetary damages as a result of that. However, that's a different area of law, but that is another area, but it's a black letter law, but it's not statutes, it's an administrative law. Then you have case law. So we talked about statutory law, we talked about regulatory law, and now we're talking about case law. Case law is what happens when somebody goes to trial and they don't like the outcome. They appeal it to in Texas, we appeal it to the Court of Civil Appeals, which is our civil appellate court. And then if they don't like that outcome, they can appeal it to the Texas Supreme Court. And again, if you don't like that outcome, you can try and attempt to appeal to the U.S. Supreme Court, which is the highest court in the land. So it comes from all these different cases that are out there. Not all cases are recorded in the books that maintain the case law. They're called the reporters. And we have what's called the Southwestern Reporter, which covers Texas. It also covers Arizona, Arkansas. It also covers Oklahoma, and it may cover one other area, but it's called the Southwestern Reporter, and we're now in the third. It was Southwestern, Southwestern Second, and Southwestern Third, and that's where we are now. And all the cases that are appealed to the Court of Appeals wind up in those reporters, and you can use that case law because it might support your position in the case that you're in now, and the finding of that court could be applicable to the finding that you're hoping to get in the court that you're currently in. So we use case law to cite, and when we cite the case, we're saying, look, this issue has already been resolved. It's almost identical to our facts. Therefore, the court should give deference and should use this case that we've cited in making its decision, and that's what we use case law for. Common law is what we deem as the law of the common people. When we're talking about filing lawsuits, because really that's what civil law is all about, civil litigation, this whole class is based upon the premise that somebody's going to sue somebody civilly, and you're going to have to answer that lawsuit, and there's going to be certain things that you have to be able to establish. And the thing that you have to establish first is what's called jurisdiction. And jurisdiction means that the court has the ability and the power to make a decision and impose that decision on the plaintiff and on the defendant. If the court does not have that authority, that power to do it, it does not have jurisdiction. Two major types of jurisdiction. We're talking about subject matter jurisdiction, which means that that the court has jurisdiction over the type of case that it is. For instance, let's say it's a real estate case. Then if this court can hear real estate matters, then that court has jurisdiction over real estate cases. Then that's subject matter. Or if it's a personal injury case, or if it's a breach of contract case, or whatever it is, the court needs to have jurisdiction over the subject matter of the case. For instance, the state court does not have subject matter jurisdiction over the interpretation of, let's say, a federal statute or the interpretation of the EPA regulations. State courts don't do that. They don't have the ability to do that. Therefore, they would have no jurisdiction to hear that. So that's subject matter jurisdiction. Then there's personal jurisdiction, also known as in personam jurisdiction. Subject matter is also called in rem jurisdiction. Two different terms, one's Latin. But the personal jurisdiction means they have jurisdiction over the parties to the lawsuit, not the subject matter of the lawsuit, but the parties, the plaintiff and the defendant. And you can establish that jurisdiction a number of ways. When you're talking about subject matter jurisdiction, before we get into personal jurisdiction, when you're talking about subject matter jurisdiction, we're talking about the basis, the subject of the lawsuit. Some courts only have limited jurisdiction. They can't hear matters, for instance, that if let's say you're in JP court, Justice of the Peace Court, well, you can't hear matters that are in excess. The last time I checked, I believe that it was $10,000. County Civil Court at Law was $100,000. Now, these may have changed since the days when I practiced in both those courts, but at some point in time, those were the jurisdictional limits. So that if you had a case that was a $250,000 case, could not be filed in JP court, because even if you won, the most you're going to get is $10,000. So that's a limitation on a particular court's jurisdiction. However, the subject matter of the court can also be limited by, for instance, if you're a landlord and you have a tenant and that tenant doesn't pay your rent each month, you want to evict them. The eviction action is also known as a forcible entry and detainer action. That's what it's called, to file something against somebody to evict them from your property. You can't file that in state district court. You can't file it in county court. Only one court in the state of Texas hears forcible entry and detainer, and that's the JP courts. So that court is a court of limited jurisdiction, but it is the only court that you can hear that. Jurisdictionally speaking, you can have a breach of contract for $5,000. Now, because it's within the $10,000, you could actually file that case in JP court. You could also file it in County Civil Court at Law, because if their jurisdictional limit is $100,000, you could file it there. Or you could file it in district court, because there is no monetary limitation in district court. So this $5,000 breach of contract case can be filed in any one of those three courts: JP court, county court, or district court. So that means that they have concurrent jurisdiction, which means that they have the ability to hear the same case. It could be filed in any one of those three courts, and you could get a judgment in any of those courts. So personal jurisdiction has to do with the parties' legal rights, the parties themselves, and we have to talk about it in the sense that, for instance, I'm going to file a lawsuit here in Texas because I am a domicile. I'm a resident of the state of Texas. So if somebody comes and does something here, for instance, I get into an automobile accident, it doesn't matter where that person's from. If it happened here in the state of Texas and I'm a resident of the state of Texas, the Texas courts are going to have jurisdiction over that matter. So that's personal jurisdiction. Forum is the legal site, also known as venue, for a particular case. It just simply means, for instance, go back to the example I gave earlier about a real estate transaction. If you had a piece of real estate and you were going to sue somebody because you believe that they gave you improper title, or they're trying to argue that they have rights to a piece of property that you claim they don't have, then the only place that you can file that, the proper venue, would be in the county where that real estate is located. So if I own a piece of property, I'm here in Harris County, and I own a property in Galveston County, I couldn't sue those people if they were trying to assert some kind of legal right to my Galveston property. I couldn't sue them anywhere except for in Galveston, because the courts say that's where those lawsuits must be brought. So there's different rules and different kinds of reasoning behind where lawsuits are filed, but it's all depending upon what's the subject matter of the case and who are the parties to the case as to where it's going to be filed. So I hope you all are picking these things up, because these are probably part of your test questions that you need to do. One thing that I can suggest too, because in this class, just like I teach another class which is business organizations, and I also teach another one on which is an introduction to legal ethics, introduction to law and ethics. I don't teach that class as often, but the business class I've been teaching for the last, maybe just since the beginning of this year. And civil procedure I've been teaching for the last several years. But you have practice tests. I can tell you this: the people that go in and take the practice tests score better when they take the regular test than the people that take that test for the first time. And the reason is because a lot of the same questions that come up in the practice test are the test questions you're going to find on your regular test, or practice quizzes. That's what they're called, or quizzes. So when you take the practice quiz, you may find some of the same questions in there that's going to be on your actual quiz for Chapter 1 and your quiz for Chapter 2. So I suggest if you have an hour, go in and take the practice quiz over and over and over again. You become familiar with the types of questions, and then you have a better feel for the kinds of questions that are going to come at you. So just be aware that that's what you need to do. Okay. So how do we acquire personal jurisdiction? Well, one of the things we talked about, the third bullet point on their property ownership, is that when somebody owns property in a particular area, then that can establish venue. That can establish that that's the proper forum to file the lawsuit. And one thing that I said earlier was if I was involved in an automobile accident and happened here in Harris County, I could file my lawsuit in Harris County. Why? Because I'm a domicile. I'm a resident of Harris County. So that gives me the reason and the basis to file a lawsuit here. But also physical presence in the forum. The mere fact that you're here at a particular time within this geographic location, which is, let's say, Harris County, Texas, that can also be the basis as to establishing jurisdiction. Consent. You can always consent to jurisdiction. If something happened, you can oppose jurisdiction or you can agree to it. If you agree to it, then the court, whether it truly should or shouldn't have it, it's not going to matter because any objections to jurisdiction you would waive if you consent to it. The other part of it is what's called minimum contacts. And this is going to be a test question, and I can explain it to you this way. One of the cases, and I think it's in the second or the third chapter that you're gonna read about minimum contacts. And the idea behind minimum contacts, and it's called this Alpharetta Spa and Peters versus Alpharetta Spa. And Alpharetta Spa was a company doing business in Georgia, and Dr. Peters was a doctor that used their services in Georgia. Well, he moved to Louisiana, and then they sent him a letter saying, you still owe us money in Louisiana, and he said that the mere sending of that letter established minimum contacts, and therefore he could sue Alpharetta Spa, who's located in Georgia, in Louisiana. And that was the whole basis for the case. Is that enough to constitute minimum contacts? And as a result of that, the court said no. You've got to have a consistent, a regular basis, a system of contacts with that jurisdiction in order for that jurisdiction to have authority over you so that Dr. Peters could sue them and maintain a lawsuit in Louisiana. If Alpharetta Spa did business in Louisiana, Dr. Peters could sue them in Louisiana, but they didn't. So that's what that case is about, and you're going to learn the details and the specifics about minimum contacts. Venue. Obviously, that's the venue is what we talked about, oftentimes called forum, but the venue is the geographic location physically within the state of Texas. Where in Texas am I going to file this lawsuit? And that's going to be, a lot of times, it's going to be dependent upon where the defendant is a resident of, because the defendant does have the right to be sued in the county in which he resides. However, if the defendant was involved in an automobile accident and he's from Austin and you're from Houston, then venue would be proper here in Houston, which is Harris County. So it wouldn't matter that he was there if the accident happened here. So that's the second point on the bullet point, is where the cause of action accrued. Okay, so when we're talking about the levels of the federal court system, it's the same as the levels on the state court system. In other words, you have the trial courts. And in Texas, our largest trial court is going to be the district court. And in federal court, you're going to have a federal district court. So there's a federal district court and a state district court. And then that's where cases are tried, and that's where juries hear these cases and they rule, and courts rule on the different motions that are filed, and they end up giving some form of a verdict. And once that verdict is rendered, then it can be collected. In federal court, if you appeal that decision, you appeal it to, you have a circuit court, which is the appellate court, which here for Texas is actually located in Louisiana as the Fifth Circuit. In Texas, we have our next level up, which is our appellate courts. And we have criminal courts of appeal, we have the civil courts of appeal. And then, as it shows here, you have in federal court, the highest court that you can go to is the U.S. Supreme Court, and in Texas we have the Texas Supreme Court. So there's kind of a corollary. Each one is opposed, starting with district court, whether it's state or federal. Then you go to the appellate level, which, whether it's state, is the civil appellate courts, and it's the circuit courts in federal. And then you have the U.S. Supreme Court federal, and you have the Texas Supreme Court on a state level. So that's just showing the different levels of courts that we have here in Texas versus the federal court system. This just gives you an explanation of what I just explained to you. So when we talk about federal law, we're talking about things that are either an interpretation of the Constitution, an interpretation of any of the articles, and if there is a federal law that has to be interpreted, it has to be heard in federal court. State courts cannot hear matters involving federal law, federal statutes, or if there is a conflict between a state and a federal law, that also has to be heard in federal court. However, in state courts, you can hear state statutes, state issues, state statutory laws, state administrative, regulatory laws. All of those things can be heard in state courts. But obviously, in federal court, if it's a federal matter, it must be heard in federal court. Okay, so we're wrapping up our first session, which is chapter number 1. And obviously, there's some things to understand. And so we're just going to kind of summarize these things. So when we're talking about civil law, we're talking about basically people suing people for money. That's what it amounts to. Damages. Damages are monetary funds or monetary damages are going to be paid because, let's say, you ran into me driving my car and you run a red light, and as a result of that, you damage my car. Those are monetary damages. You got to pay and repair my car or replace my car. I was physically damaged. That's also damages, and you're going to have to pay some type of a monetary amount to compensate me for the pain and the suffering and the mental anguish that I sustained as a result of your negligence. So first we have to get that finding of liability, and then once we have a finding of liability, then we move to damages, and the jury in state courts, just the same way in federal courts, then determine how much money should be awarded. The U.S. Constitution, which we didn't spend a lot of time with, and I just told you, obviously, the branches of government and the three branches of government, from legislative, executive, and judicial. The judicial, obviously, is what we're focused on because we're talking about the court system. We're also talking about different types of law because there's statutory law, which we talk about, are what I call the black letter law. There's state statutes, federal statutes. There's the regulatory law, which comes from administrative and regulatory agencies. And I told you, for instance, the Environmental Protection Agency would be an administrative. The Securities and Exchange Commission has statutory and regulations that would be filed. That's all administrative and administrative and regulatory. And in state court, we have the same kinds of things. We have the Texas Alcohol and Beverage Commission. That's a regulatory agency, and they have statutes and regulations that you must abide by. So there are statutes, there are regulations, there's case law, and there's common law. And those are the different types of laws that are out there and the different sources of law that we can draw on as a paralegal. So when you're trying to figure something out, it may be something that comes from common law, and maybe something that comes out of case law, or it may be a statute that's favorable to your case. Any one of those things can be cited in support of whatever the argument is that you're making in your case. 3 levels of court. So we're talking first about trial courts. Then the next level up is going to be the courts of appeal, whether it's the Fifth Circuit in federal or the Court of Civil Appeals in state. And then you have the U.S. Supreme Court, which is the highest on the federal side, and we have the Texas Supreme Court, which is the highest on the state side. So those are the varying levels of courts. Cases start out in the district courts, which are the trial courts. They move up if they're going to be appealed to the next level, and then they end up in the Supreme Court if they're going to be appealed again. So that's the information for Chapter 1. We're going to take about 5 minutes, but obviously it doesn't matter because you can fast forward or you can move to this. I'm going to turn it off, and I'm going to pause the recording, and then I will be back in just a few minutes, and we will do Chapter 2, and you guys are free to take a few-minute break. Okay, so now we're back from break, and we're going to go into Chapter 2. Here we go. So, who are the participants in the legal system? We're going to talk specifically about plaintiffs. We're going to talk about judges. We're going to talk a few other things. This is a short section, so probably within 30 minutes we'll be finished. And then, and what I would prefer that you all do, obviously this is going to be this coming Monday's class. Then the following Monday, if you guys have questions that relate to something that went on in Chapter 1 or 2, save those questions for class. That'll be your second class, which in essence we'll really be talking about Chapters 3 and 4. Save your questions about Chapter 1 and 2 for that class. Write them down, make notes, and then we'll go over those to make sure that you've had the opportunity to pose whatever questions or comments or whatever to me, and then I will, I'll be happy to answer those. So let's talk about what we're going to do here in Chapter 2. So we're going to talk about judges and what happens to those. We're going to talk about a little bit about lawyers and how people become attorneys, how legal professionals work with each other, a little bit about courthouse personnel, and we'll go from there. So the judge. The judge has a particular role. The judge is like the referee, because you got two lawyers who are very zealous about their cases, and they're arguing those with a lot of passion, and somebody's got to be the referee between the two of those, and that's what the judge does. But the judge also decides certain issues, but it's the law of the case, not the facts of the case. The facts of the case is the province of the jury, if it's a jury trial. If it's a bench trial, then the judge is the trier of law and fact. If it's a jury trial, then the judge is the trier of law and the jury is the trier of fact, which means the judge determines what law is applicable and the jury determines what facts are applicable when rendering a judgment in the case. Judges obviously preside over criminal and civil cases, different sets of judges, different sets of rules. The Texas rules of criminal procedure are completely different than the Texas rules of civil procedure. But they also have their own ethical codes, and there's limitations as to what they can do. And if they are not impartial and if they are not neutral, then they must recuse themselves from cases. I had a case recently where it was a lawsuit that I was personally involved with, and we ended up in a judge's court, and I just happened to know who that judge was. Now, I hadn't seen that judge in probably 10 years. It's not like we were golfing buddies and we went out every week, or that we went and had drinks, or we did things socially. But I did know him, and we knew each other on the street. Whenever we saw each other at functions, we'd say hello, we'd kind of catch up with family matters and such, and that was it. Well, this judge felt compelled to recuse himself from this case because of his knowledge and the fact that we were friends. So that's generally what happens. Not always a case, just because you know somebody. Think about it. Judges know most of the lawyers in town. They can't recuse themselves every time some lawyer comes into their courtroom that they know. But in this case, the judge did exactly that. So the first thing I talked about was that he's a referee. So somebody files a motion to compel because they served some discovery and the other side didn't answer the discovery. You're down there before the judge, and the judge has got to kind of be a referee between the parties. He's got to listen to one side, listen to the other side, and he's got to make a determination as to why he should rule one way or the other. And then he does that. So they make these rulings, they listen to motions. During the course of the trial of the case, they can be a fact finder if it's a bench trial. They'll hear evidence, and they'll determine what evidence is admissible if it's a jury trial, and that's part of what the judges are supposed to do. That's their role as judges. The ethical codes, there's a code of judicial conduct, just as there's a code of professional conduct, but there is a code of judicial conduct, both federal and state, that governs what these judges can or can't do. In other words, they can't make decisions simply because they don't like the outcome of the case. They can't make a decision because they don't like one of the parties or the other parties. If they feel that they can't be fair and impartial, then that's the point in time that the judge needs to recuse themselves. These ethical codes, we have, they're codified. A lot of law firms will post these in their law offices, and they want the employees to know what the Code of Professional Responsibility is all about. And likewise, judges should know what the Code of Judicial Conduct is all about, what things the judges must refrain from and what things they can engage in. So judges can then determine whether or not lawyers are acting ethically and acting within their roles under the rules of professional conduct. And so if they're not doing that, then the judges can sanction these individuals, and that can have an effect on your case. However, there's one other agency, which is the State Bar of Texas, that also watches what lawyers are doing and also watches what judges are doing. And the State Bar of Texas has several tools at its disposal that it can use to do something to lawyers who are violating the rules. If it's a very minor violation and it's something that, nobody was hurt and nobody lost money, but it was something that maybe a lawyer forgot to file something timely, but then later was able to get it done, then they're usually going to do what's called a private reprimand. This violation that they're saying that was involved, they will simply tell them, said, look, I'm privately reprimanding you. Be on notice. If you commit another act along the same lines as this, it's going to be upgraded to the next one, which is a public reprimand. The public reprimand says this lawyer violated his ethical duties and responsibilities to a client by commingling funds. That's a big one. There's a lot of lawyers that don't understand what trust accounts are for and how to use trust accounts. So they end up mingling their funds with clients' money, and that's not supposed to happen ever. If that happened and the client claims that they lost money, then they're going to be reprimanded, and it's going to be published usually in the State Bar Journal. There's one that lawyers get every week, every month. And in there's a disciplinary section. It'll have all the different disciplinary actions that are taken, and that's where the public reprimand would be printed. The next stage, which is even more serious, is a temporary suspension. And that would be if a lawyer violated something that was a serious ethical violation. For instance, lawyers are not allowed to go out and solicit clients. They're not allowed to go to the hospital emergency room and hand out cards to people that are being wheeled in from an automobile accident. You can't do it. If you do it and you're caught, and they will catch you, they will sanction you, and usually they will suspend your license for a period of time, which means that you cannot practice law for that period of your suspension. You must have another lawyer come in and handle your cases during that period of time until the suspension is lifted or it expires. The more serious after that is going to be disbarment, and that means that the lawyer is losing his license to practice law and cannot go back to practicing law. Usually that's a result of criminal conduct that a lawyer engages in, and you lose your license. And then the last of all of these is what's on there, and that is when you've engaged in some kind of criminal conduct. You have been disbarred, you've lost your license, and now you're going to be tried in a criminal court. And in that criminal court, they're going to determine your guilt or innocence and whether or not you're going to go to jail. So that's generally what happens. So those are the main areas of different types of sanctions. So here's some of these common ethical violations. The commingling of funds is a big one. That's one where, like I said, lawyers don't seem to understand that a trust account is also known as an IOLTA account. IOLTA, it's an acronym and it stands for, I don't know what it is, but it's a trust account. Lawyers Trust Account, something, I don't remember what it stands for, but I know that an IOLTA account is a trust account, and it's client money that goes in there, and it's client money that gets dispersed from there, not from your operating account. Failing to do things, failing to follow up, failing to write letters, failing to respond to client contacts, failing to do any of those things is considered a lack of being diligent, and that's also considered an ethical violation. somebody's calling you and they're trying to get information on their case, and you keep blowing them off and blowing them off and blowing them off, then at some point in time they're going to report you to the state bar, and they're going to file a grievance against you, and then you're going to have to answer for that. So one of the things that I've used paralegals for, and I've used many, many paralegals over the course of my 35 years of practice, one of the things that I've done is if I don't have time to be able to talk to somebody about a particular case, and I know the paralegal is very familiar with that case, I might have the paralegal make the phone call for me, and I'll say, look, just tell him this, tell him this, tell him this. Anything more than that, you can't answer. And that way, at least they're getting some phone call back from somebody, and they're answering some questions and giving them a little bit of information, and at least the client feels like they're not being ignored. And that's an easy way to avoid a very, very simple ethical violation from occurring. Okay, so civil attorneys, you generally represent one side or the other. Now, I've done both. For the majority of my legal career, probably the first 20-some years, I was a plaintiff's lawyer. I represented the aggrieved party, whether it was a deceptive trade practice case or a breach of contract case or a personal injury case. I always represented the plaintiff. And then at some point in time, probably within the last 15 years, I started representing my clients who unfortunately were being sued, and now I was their defense attorney. And I continue to represent people who have been sued in civil litigation. And most all of the litigation that I've done over the last, let's say, 12 years has been nothing but defense work. Individuals who have been sued, I have defended them in legal actions, and that's part of what I did. I'm also a certified mediator and arbitrator, and so some of the things that I would do would be as an impartial. I would be a mediator trying to settle cases, or I'd be an arbitrator deciding cases that people didn't want to go to trial on, and they could have them decided by an individual such as myself. So those are the areas of law that most lawyers fall into. Paralegals, however, can be used both on the plaintiff side and on the defense side, and you can find yourself in one or more particular areas. For instance, you guys as paralegals need to make a decision at some point in time, the type of law that you would like to be engaged in. And maybe you don't know enough yet about the various types of law to know which area of law you would have more of an interest in. But that's something that you kind of have to keep your eyes open, and you have to look and see, do I want to practice civil law, and do I want to do personal injury law? Do I want to do commercial litigation? Do I want to do insurance defense work? So there's all different areas that you can do. The next thing that you want to figure out is, do I want to work for a small firm, a medium-sized firm, or a large firm? If you're working for a small firm, you're going to wear many hats. You're going to do a lot of things. You're going to be contacting clients. You're going to be taking witness statements. You're going to be going to the scene of an accident and shooting photographs and maybe measuring skid marks. You're going to be doing a lot more than just sitting in the office and with a particular task. However, the larger the firm, the more likely that you as a paralegal are going to be what we call pigeonholed, which means that they're going to find that there's a particular skill that you have. Maybe you're very, very good at summarizing depositions. And then the next day you're going to walk into your office, you're going to find 50 depositions sitting on your desk, and you're going to have to go through and summarize each of those, which means the deposition could be 100 pages, and you're going to reduce that down to maybe 3 or 4 pages of really pertinent information. And that's called a deposition summary. So you may be very good at that. You may be very skilled at research, legal research, finding cases to support your position in a particular case. You may be very good at interviewing witnesses or preparing witnesses for their deposition. There's a lot of different skills. You may be very good at legal writing, writing briefs, writing motions, memorandums, all these kinds of things. So you kind of have to figure out where you fit into the scheme of things. And then if there's a particular skill you find yourself doing very well, you want to hone that skill. You want to be very, very good at that skill. That's how you make yourself indispensable to these lawyers out there who are going to be looking to hire you. So think about it. Type of law that you want to practice, size of the law firm that you'd like to work for, And is there a particular skill that you possess as a paralegal that you would like to be able to do on a regular basis? And once you make those decisions, then things will be a little bit easier because you'll know the type of law firms to go interview with, and you'll know the type, because there's going to be a particular area of law that you're interested in, and not all firms practice all areas of law. Some people are generalists, some people are specialists, and that they only practice a particular area of law. So, but you'll find something that meets your needs and that kind of floats your boat, and that's what you find. You know, that's what I want to do, and then that's what you shoot for. These are some of the things that paralegals do. I mean, I'm sure you've probably discussed this before in other classes, but these are things that I've just described with you. Interviewing witnesses, preparing witnesses for depositions, meeting with clients, doing client interviews, getting all the client information, taking witness statements. All of these kinds of things are things that paralegals do on a regular basis, and you kind of develop skills in doing each of these, so that the more you do, the more you understand about it, the better off you are, and the better you are at doing those jobs. And again, that's again what makes you indispensable. So what about the other players? So since you're in the litigation process, because we're talking about civil litigation, that's what civil procedure has to do with, there are the other side of these people, the people that work for the judges, the people that are down at the courthouse. The clerk of the court. The clerk is the kind of presides in the courtroom. You have the judge, and then you're going to have the judge's right-hand man or woman is going to be their clerk, and they're going to know everything about this particular judge. They're going to know the idiosyncrasies of this judge. They're going to know what things this judge likes and what things this judge does not like. They're going to know about how to get hearings set up. There's a court coordinator that also works closely with the court clerk about scheduling trials and scheduling hearings and scheduling continuances and motions and all these kinds of things. That's the court coordinator. It's not a bad idea once you get on with a particular law firm, if you're engaged in the litigation process and you're going to be doing a lot of litigation, go down to the courthouse and meet some of these clerks from some of the courts where you may have cases pending. It's always nice when the clerk of the court knows somebody. You can take them to lunch. There's nothing wrong with that. They enjoy it. And you can go down there. You can meet with them, find out things about how their system works, so that when you make a phone call and they're talking to you, they're picturing you. Now there's a face that they can put with the name. And you know what? There's a lot of politics that go on with the courts. So sometimes it's just a matter of how well they like you as to whether or not they're going to give you something that you're looking for. You know, let's say you got a witness and the case is coming up for trial, and this witness is going to be out of the country, and this is a very important witness. You need this continuance. You know, you need a break. You need the clerk to help you, and they can do that. They can. Judge may not even know that it's going to be continued, and they can say, Your Honor, we're going to continue this case and this case. Judge doesn't care. He's just down there to try cases, and if the case gets continued, it gets continued. And the clerk can have all the power in the world when it comes to that particular kind of a thing. So, not a bad idea to become familiar with this court personnel. Probate court, unless you're doing wills and estates, I don't think you're going to have a lot to do with the probate court. And the tax office, again, unless you're working for a firm that specializes in tax matters, you're probably not going to deal with that. Now, the tax office keeps extensive records about real estate which are available to the public. That's really not the tax office. That's the clerk's office is the one that keeps these records. There is a tax office in the county clerk's building, but there's going to be a real estate records section, and they're going to keep all of the records of real estate because you might be practicing real estate law. And maybe if you're in that area, you may need to know those clerks because you may be going down there and getting copies of deeds and different types of warranty deeds and deeds of trust and all these different kinds of legal instruments that are on file with the court. So that could be something that you might have to deal with. So anyway, that is all there was to Chapter 2, and that's why I felt like you guys can get by with tonight because this information, as informative as it is, it's obviously not the crux of what the civil procedure class is about. So, and unfortunately, it just came at a time when I was going to be out of the country because you're reading this now. I am out of the country. Things that we talked about the different types of submission of documents in the court system. We talked about judges and the rules of ethical consideration. We talked about the code of judicial conduct and professional conduct and about violations, the kinds of things, sanctions, disbarment, private, public reprimands, all those kinds of things that can happen. And those are all things that I think are important for you to know, but obviously it's going to be things that you'll find as you get to work in an office. We also talked about it from the standpoint of a paralegal. What are the things that paralegals can be used for in a law office? And I described a number of things, you know, summarizing depositions, interviewing witnesses, going to the scene of an accident, you know, marking exhibits. Especially if you're going to do trial work, you know, you could be very beneficial if you become very astute at the trial aspect of the case and being an assistant to the lawyer going to trial. Then you go to trial with the lawyer every time the lawyer goes to trial, and you're down there with your trial notebook and everything that goes on with that. So those are some of the things we've talked about. We talked a little bit about the other players, the judges as neutrals, court personnel, the clerk of the court coordinators. Those are all people that I think is a good idea for paralegals to get to know and to at least have some familiarity with these people, so that if it ever comes to the situation that you need a favor, you know, again, if they know you as opposed to you being a complete stranger, they're much more likely to grant whatever relief you're looking for, as opposed to not doing anything with someone that they don't know. So, like I said, there's a lot of politics that go on with the court system, and you might as well take advantage of it and learn about it early. So, okay, again, that's the end of Chapter 2. We've done 2 chapters for this session. And again, if you have questions with regards to any of these issues that we covered in Chapter 1 or that we covered in Chapter 2, then I need for you to write them down, and then at the beginning of class, we'll have more than enough time. I'll have probably 30 minutes, you know, in the next class session, which is week number 2, for you to bring in your questions and answers, and I'll go through all that stuff with you, and be happy to go over that stuff with you. So, okay, so that is the end of our class session. So you guys have a good weekend. Get your work in, and again, I will see you next session. All right, y'all have a good evening.